Welcome once again to Lehto's Law. Here's Steve Lehto.
Had a couple people send me this story out of Ohio, and it's a fascinating story because it plays into what people think of as burglary. And burglary is a concept that goes way, way back in our common law, but also has been codified in most states, and depends on how it's codified versus common law as to whether or not it makes sense. So the headline from the Columbus Dispatch, written by Laura Bischoff, says, he took a $500 leaf blower, but Ohio Supreme Court says it wasn't burglary. And most people hearing these facts would say, yeah, it sounds like burglary. But then when they hear how the statute's written, they go, well, maybe not. And it's obviously something wrong to steal someone's $500 leaf blower. But in September 2020, a man pulled up to another man's house as that man was doing yard work at his own house. The man who pulled up hopped out, walked up to the man's open garage, picked up a $500 leaf blower, and drove off with it. So the Ohio Supreme Court just said that what the man did not constitute burglary because he did it in plain view, without force, without stealth, without deception. He just walked up and grabbed it and walked off. Therefore, it's not burglary. Now, they're not saying it wasn't a crime, but they're saying it wasn't burglary, and that's where a lot of people, including myself, have a problem with this. The court threw out the conviction, but told the county common pleas court to instead convict him of misdemeanor criminal trespassing because the man had been sentenced to 8 to 12 years in prison on the burglary offense. And the question is, misdemeanor criminal trespassing obviously is less than burglary, but trespassing implies that I'm there without permission. But what about the fact that he stole something? Isn't theft of something that's $500 in value also something? But they didn't mention that. So turns out here that the man whose leaf blower was stolen testified that as the man walked up to his garage, he smiled. He smiled, which led him to believe initially that he was not there to steal anything. Didn't know why he's there, doesn't know the man, but the man walks up and smiles. But when he grabbed the leaf blower, the homeowner told him to stop and put it down, but instead he threw it in his truck and drove off. So the homeowner had a cell phone with him that had a camera on it, took a bunch of photographs of the man as he drove away. So this is a pretty clear-cut case that they got the right guy and they know what he did. The question is, was that burglary? And the Supreme Court wrote in a unanimous decision, nor did the defendant deceive, mislead, lie to, or trick the homeowner into granting him entry into the garage. Therefore, he did not commit burglary under Ohio law because he did not gain access to the garage by force, stealth, or deception. So they're saying that if he broke in, that'd be force. If he snuck in, that'd be stealth. Or if he went in deceptively, like said he's going in for one thing but went in for another. And apparently you need to have one of those three things to qualify as burglary under Ohio statute. Now that's strange to me because I've talked about this before. Burglary is a common law thing that's been around for a long, long time. It goes way back to the other side of the pond, as we say. And common law burglary in the old days originally meant breaking and entering into the dwelling of another at night with the intent to commit a felony therein. So it required you to be breaking and entering. It required it to be a dwelling, so a garage wouldn't count. It would have to be at night, so daylight wouldn't count. And with the intent to commit a felony therein. But over the years, they've broadened this and categorized it and made it work because you can imagine all kinds of situations where if someone breaks into your garage that's attached to your house, have they broken into your dwelling? What about if they break into your garage that is detached from your house? Well, obviously that's not your dwelling. You don't live in there with your car. So the question then becomes, shouldn't we, though, still call that burglary? Like, we don't want people breaking into your garage just because it's not your dwelling. So most places have said, okay, if you break into someone's building to steal something from it, that'd be burglary. Well, the problem, of course, is they're saying, well, he didn't break in. He simply walked up and took something. And so many states will actually say that if you enter a building that is not yours with the intent to commit a crime there, that's burglary. And that, to me, is the one that makes the most sense. Because everyone knows If it's your building, you can go into it. You can invite people into it. But other people cannot just invite themselves in and take stuff. So it seems to me that the Ohio statute saying you've got to do it by force, stealth, or deception is strange. Because that means that I can run up to your house, wave, run inside, grab some stuff, and run away. And it's not burglary because I waved. So in case you're curious, I also did look up a couple other definitions. Depends on where you look it up. Burglary is sometimes called breaking and entering. And again, that would imply breaking. And this guy didn't break anything or have to get through anything. He simply walked in. Sometimes called housebreaking is the act of illegally entering a building or other areas without permission. And usually it's to commit a crime there other than simple trespassing. And trespassing, of course, is simply the idea that you're on someone else's property without their permission and they would like you to leave. And it's presumed that you don't want someone to come onto your property to steal your stuff. So this is a strange case, but this is an example where I'm guessing based on the unanimous opinion of the court that it has to do with them simply reading the statute and saying, well, he did not gain access by force, stealth, or deception. Therefore, it's not burglary. And it changes it from a very, very serious crime to a simple misdemeanor, which sounds like he's going to get off a lot lighter. So what I would urge you to do if you're in Ohio and you have the inclination to do so, contact your legislature and say, by the way, I just saw this crazy case come down out of the Supreme Court here. And it seems to me that somebody walks up to your house and grabs something because they can, but they enter your house or your garage to do it. That ought to be burglary. That ought to be. I mean, it seems to me. Now, you're free to disagree with me if you want. You can say, no, Steve, I'm in favor of this. I like the idea about people walking and grabbing stuff out of my open garage. I'm not. That could just be me, though. That could just be me. So I'm always interested to see how these laws evolve over time. But I am surprised that here the Supreme Court actually said you're going to remove this conviction and replace it with this other conviction for criminal trespass. They don't mention the theft. And the idea that someone trespasses on your property, they can just walk in and walk off. That can be trespassing. So they walk in, grab a $500 item and walk off. That's got to be more serious than the simple trespass. Unless they're saying, well, it becomes misdemeanor criminal trespass because he stole something of value that was not his and it's $500, blah, blah. That could be too. That could be. But I'm a little surprised. But then again, like I said, when they drafted the statute, they probably thought, well, force, stealth, or deception. That covers all the different reasons and ways. That covers all different ways that you can get into somebody else's building to steal something. Well, what if you just run up and grab something? Smash and grab type thing. But you just run up and grab it and run off. I mean, I understand the smash and grab would be force. But I'm talking about people running up, grabbing something, and running away. And in my mind, that ought to be burglary. So Michael and Zachary both sent us. Thank you very much. Laura Bischoff wrote that for the Columbus Dispatch. We'll see if the legislature takes any action. But he took a $500 leaf blower. But the Ohio Supreme Court says that was not burglary because he walked up and he smiled. There you go. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. The ratio of dreaming to doing varies inversely with the rate of accomplishment.